Immigration options for victims of violence at the hands of abusive United States citizen and lawful permanent resident family members. Welcome to Immigration Television, the leader in legal media and informational videos pertaining to United States immigration law. My name is Tarek Hashmi. I'm an immigration attorney based in Miami, Florida, and today's topic is options for those individuals that are victims of domestic violence. Let me begin with a little bit of history regarding how the law developed. 20 years ago, if you met an immigrant who was the victim of family violence, who was being sponsored for lawful permanent residence by a family member, there was little that could be done to help that immigrant victim pursue immigration status. Today, after years of legislative changes to the INA, which stands for the Immigration and Nationality Act, for victims of domestic violence, spouses, children, and now in some cases even parents who suffer abuse at the hands of United States citizen and lawful permanent resident family members, they now have options that allow them to pursue immigration status on their own. This presentation guides you through 3 specific options for immigration victims of domestic violence. The first topic is what they call Vawa self-petitions, also referred to as I-360 petitions due to the specific immigration form, utilized in the application process. The second class of individuals eligible to pursue relief under domestic violence protections are battered spouse or child waivers. These are applied for via the I-751. And the third class of individuals are those which are called Vawa cancellations. These are filed upon the EOIR 42B. I would like to address a certain issue which we call imperfect privacy protections. Many victims of domestic violence may fear that abusive family members will try to interfere with their immigration filings, either by providing negative information to U.S. Citizenship and Immigration Services, USCIS, or U.S. Immigration and Customs Enforcement, ICE, or by seeking to obtain copies of documents filed with USCIS. It is extremely important to assure one's client that the privacy of their I-360, VAWA self-petition, I-751, battered spouse or child, or the EOIR 42B, VAWA cancellation. Be aware, however, that in practice, USCIS does occasionally make mistakes and accidentally provides limited information such as receipts and notices of interview to abusive family members. Protections for domestic violence victims are weakest with respect to reports made to immigration authorities about victims' immigration violations. Now, VAWA prohibits government officials from making an adverse determination of admissibility or deportability of an alien under the Immigration and Nationality Act using information furnished solely by an abuser or agent of the abuser. Furthermore, if removal proceedings are initiated against a non-citizen domestic violence victim, the notice to appear, also called an NTA, which is the charging document in removal proceedings, must contain a certification of compliance with the privacy mandate of VAWA. I must say that ICE's current policy with respect to protections for such applicants means that you should not provide domestic violence victims with false assurances that they are protected from enforcement actions. This in mind, defense practitioners should stand ready to contest NTAs not only for lack of certification of compliance with the VAWA privacy provisions where required, but also where such certification is present, as ICE's actions can be easily challenged. It is important to remember that your client, victim of domestic violence, may well be in danger. Every year in the United States, intimate partner violence results in nearly 20 million injuries and nearly 1,300 deaths. As an immigration attorney, your role is to provide neither false assurances nor domestic violence counseling. Rather, refer your client to a domestic violence service provider who can guide your client through safety planning for herself and her children. The heart of any immigration case for an immigrant victim of domestic violence is her story. When interviewing your client, be careful with why questions such as, why did he hit you? Why did you ever marry him? Why did you stay with him? Let's now discuss the VAWA self-petition. A VAWA, V-A-W-A, which is the Violence Against Women's Act, self-petition is conducted on Form I-360. It is a variation of a relative petition. VAWA self-petitioning is open to close family members, the parents, spouses, and unmarried children under 21 years of age of United States citizens. These are immediate relatives, as well as to spouses and unmarried children under 21 of lawful permanent residents. The VAWA self-petitioner keeps the same place in line. This is the priority date of a relative petition filed under Preference Category 2A. This occurs whether or not the relative petition has been withdrawn. And secondly, if an application for adjustment of status is already pending, and the relative petition has not already been withdrawn or denied, no new application for lawful permanent resident status is required. The criteria for a VAWA self-petition may be summarized as follows. First, one needs a good faith marriage to a United States citizen or lawful permanent resident for marriage-based VAWA self-petition cases. This is not so for parent-child-based cases. Now, qualifying relationship. One must have a legally valid marriage to a United States citizen or lawful permanent resident. Qualifying bigamy to a United States citizen or lawful permanent resident. Recognized parent-child relationship where the abusive parent is a United States citizen or lawful permanent resident, or a recognized parent-son or daughter relationship where the abusive son or daughter is a United States citizen. The next issue is the matter of abuse, physical battery, extreme cruelty. Another issue that is mandated in these proceedings is joint residence, and an individual also needs good moral character. In addition, if the marriage has been terminated within the past 2 years, the VAWA self-petitioner must demonstrate a connection between the divorce and the abuse. And lastly, if the abusive petitioning relative has lost United States citizenship or lawful permanent resident status within the last 2 years, the VAWA self-petitioner must demonstrate a connection between the loss of status and the abuse. And now a word of caution. These are barriers to approvals of VAWA self-petitions. Please note that many immigrant victims of domestic violence have been in compromised situations, and some have committed acts that create bars to obtaining approval of immigrant status as a VAWA self-petitioner. First, prior marriage fraud. A non-citizen who has previously been the beneficiary of a petition for alien relative, Form I-130, based on a marriage later determined by federal immigration authorities to have been entered into for the purpose of evading the immigration laws, may not have a petition for alien relative or a VAWA self-petition on Form I-360 approved. Good moral character. Any activity in the domestic violence victim's past, distant or otherwise, that is not related to domestic violence may preclude a finding of good moral character under INA Section 101F. Under current USCIS interpretation of INA Section 204, many past acts serve as lifetime bars to VAWA self-petitioning on Form I-360. An important part of the case is the VAWA self-petitioner's statement. The most important part of any VAWA self-petition is the victim's story in her own words. Where you have an opportunity to influence the timing, it is preferable to file the VAWA self-petition prior to the issuance of a final divorce decree. Immigration status of the abusive spouse, parent, son, or daughter. Determine if your client, who is the victim of domestic violence, determine if they have copies of the abusive spouse's birth certificates, green cards, naturalization records, or U.S. passport pages. If the abusive relative is a United States citizen born in the United States, you must look to the law of the state in which the United States citizen was born and try to obtain copies in that jurisdiction. If the abuser is or was a lawful permanent resident, a naturalized United States citizen, or has previously filed a petition with the federal immigration authorities, United States CIS can look up the abuser's immigration status. Keep in mind that if the abuser has lost immigration status within the last 2 years, and that loss of status can be connected to the domestic violence, then your client will still be eligible to file a VAWA self-petition. In addition, as with divorce, post-filing loss of status is irrelevant. Let's talk about abuse, either physical battery or extreme cruelty. Sometimes people do not realize that some of the bad things that have happened to them are forms of abuse. For example, isolation of friends and family, economic control, or forced sex are all common in domestic violence, but victims of these behaviors often do not realize the relevance of such behaviors as part of a pattern of abuse. Police reports, court records, protection orders, and other documents indicating involvement with government authorities are helpful, but they are not required. Mental health and domestic violence workers also can provide useful statements, but like police records, they are by no means a requirement. Ask providers not to focus so much on diagnosis like post-traumatic stress disorder and depression, but rather ask why. In the worker's professional opinion, he or she believes that your client has suffered domestic violence. Remember, physical abuse is not required by statute, and that extreme cruelty can provide the basis for a VAWA self-petition. As the Ninth Circuit in the landmark case Hernandez v. Ashcroft noted, Congress clearly intended extreme cruelty to indicate non-physical aspects of domestic violence. Let's now turn to the good moral character requirement. Good moral character, not mentioned in the INA provisions relating to United States citizen and lawful permanent resident initiated relative petitions, is a statutory requirement for the approval of a VAWA self-petition. If your client has no arrest record and does not fall within the class of persons described in INA Section 101F, there is little that your client must do other than state that she is a person of good moral character and provide police records of previous residence places. Primary evidence of self-petitioner's good moral character is her affidavit along with a local police clearance or a state-issued criminal background check. Any VAWA self-petitioner who has been arrested, even if those charges were eventually dismissed, or may otherwise fall within INA Section 101F, will need to provide in-depth explanations. I hope you find this overview to have been helpful. Remember that this is a very complicated area of immigration law. Any petitioner should seek the help of an experienced immigration attorney. Thank you for joining us on Immigration Television.